Hi, I'm Bill Kirshner, an Assistant General Counsel with the FLRA's Office of the General Counsel. In this series of videos, the Office of the General Counsel is providing training on collective bargaining, one of the most complex subjects under the Federal Service Labor Management Relations Statute. This series will cover what is included in the scope of bargaining, what represents good and bad faith bargaining, duty to bargain issues, including term, midterm, and an in-depth analysis into change bargaining, addressing both what is a change and what impact is necessary to support the finding of a bargaining obligation. What defenses exist that may modify the duty to bargain, including covered by, contract interpretation, and times when grievances, not ULPs, should be pursued. And lastly, remedies when bargaining violations occur. You will soon see that collective bargaining is one of the most complex subjects under the statute. If you do not watch the entire series, you may miss critical information affecting your ability to bargain successfully. Why is bargaining so complex? It's complex because there are three broad factors simultaneously at play in bargaining cases: scope of bargaining, duty to bargain, and defenses to the duty to bargain. Let's explain what each of these mean. First, scope of bargaining addresses what topics are generally included or excluded in the matters a union may be entitled and an agency may be required to bargain. Second, duty to bargain sets out when the duty to bargain arises. Generally, this encompasses term, midterm, and change bargaining. Third, defenses to the duty to bargain need to be examined. Sometimes it appears a matter is within the scope and duty to bargain, but for one of several legal reasons, the union does not have a right and the agency does not have a statutory duty to bargain. This video addresses the duty to bargain, the times when parties have an obligation to bargain, and times when parties are not required to negotiate. This series introduces terms and concepts the OGC will raise in investigations which help govern the FLRA in adjudicating bargaining disputes. It does not represent legal advice. Now, on to the presentation. There are three times when a duty to bargain exists: term bargaining, midterm bargaining, and bargaining related to proposed changes. Term bargaining can be broken into two categories: initial contract bargaining and bargaining when an existing contract is about to expire. Regarding bargaining initial contracts, following certification, unions have the right and employers have the duty to negotiate an initial contract. The statute requires all contracts include provisions for the filing of grievances and for neutral third-party arbitration. Additionally, these agreements will be put in writing if requested by either party. In the federal government, these agreements can be called master agreements, term contracts, or collective bargaining agreements. Turning to when an existing contract is nearing its expiration date, what are the most common issues that come up when a contract expires?
Looks like our 3-year contract is about to end.
That's true. What are our options?
Let's look first at the simplest scenario.
Well, we have a clear rollover provision that says our contract rolls over for another year if neither party requests to renegotiate. We don't want to reopen the contract and rebargain it in the open window, do you?
No. No changes are necessary.
In this scenario, the contract simply rolls over for another year, and another window period will open near the end of the next term. But what if the contract does not include a rollover and only says it terminates after 3 years?
We have no rollover clause. What will happen if we do not execute a new agreement?
Let's ask the FLRA.
In this scenario, mandatory provisions continue unless notice and opportunity to bargain is given. Permissive provisions carry on as a past practice that may be discontinued with notice. Moving to another scenario, what if one party says it wants to reopen and bargain a new contract?
We're in our open window. I'm handing you notice that we want to renegotiate, but we only want to make 2 small changes.
Thanks. What happens now?
The parties bargain a new contract. If they agree on the changes and sign before expiration, they simply implement a new contract.
Well, we're glad you reopened because we also have several provisions we'd like to propose changing.
That is your right, but we may not be able to complete negotiations before the 3-year term is up.
So what happens if we can't sign a new contract before the old one expires?
If the old contract addresses that, the parties do what the old contract says.
Well, the contract says, if a new agreement is not reached by the termination date, then the contract continues. which means there's never a time when we're not living under a contract.
Let's make sure to include that concept in the new contract. It will allow us plenty of time to renegotiate and not risk being without an enforceable contract.
But what if the expiring contract is silent regarding this scenario? The result is the same as if the contract had no rollover provision at all. Mandatory terms continue and can be changed only with notice and bargaining. Permissive terms can be terminated with only notice.
There are no rollover terms, but we are not happy letting the contract expire while we negotiate the new contract, which could take some time.
Could we sign an agreement now to roll over the old contract until the new contract is in force?
Sure, we see no reason not to.
Neither does the FLRA. Parties are always free to enter into agreements and then live under the terms of those agreements. For many years, most contracts had 3-year terms, but in recent years, the practice of longer-term contracts, some as long as 7 years, are now more common. Longer contracts may result in an inability to renegotiate articles which no longer fit changed circumstances. Parties can always mutually agree to modify a contract. However, if either side declines to change the terms, the existing provisions remain in effect. Remember, federal contracts are enforceable. When a contract is violated, remedies can be obtained. Accordingly, contracts need to be entered into thoughtfully, carefully, and with the understanding that there are few legal justifications excusing contractual violations. Let's now discuss midterm bargaining. The authority noted in this DOL case, absent a reopener clause, parties are not permitted to demand midterm bargaining over matters that are covered by an existing agreement. However, until 2019, the statute was interpreted as including a duty to bargain during the contract's term when matters are not covered by a valid in-place agreement. Under this pre-existing standard, in a second DOL case, the union wanted to bargain about parking for unit employees. The authority upheld the judge's conclusion that since parking was not previously bargained in any agreement, the union was able to validly demand a bargain, and the agency had a duty to bargain in the middle of the contract's term. In 2019, the authority issued a policy statement noting the statute neither requires nor prohibits midterm bargaining. Instead, the statute leaves midterm bargaining obligations to the parties to resolve as part of their term negotiations. So, what standard will be used in the future? It is not clear what standard the authority will apply when reviewing pre-policy statement agreements that failed to address midterm bargaining. Parties previously operated under the assumption that a lack of a midterm agreement resulted in the duty to bargain midterm over matters not covered by existing agreements. In short, midterm bargaining represents a possible time for addressing matters not contained in or covered by existing agreements. Now, let's discuss change bargaining. What occurs when management proposes to change conditions of employment not covered by existing agreements? To answer this question, we need to examine the authority's change bargaining precedent. Change bargaining represents the majority of federal sector bargaining. This scenario typically occurs when management wants to implement a change in a matter not addressed in an existing agreement, or where the agreement expressly allows future changes subject to notice and bargaining. While both parties may always agree to bargain over previously negotiated terms, neither party is required to negotiate during the contract's term unless the contract requires such bargaining. Instead, parties to a valid agreement may opt to maintain existing agreements and even force compliance with them to remedy breaches. Words in contracts do matter, and traditional contract law permits enforcement of valid contracts. But contracts rarely address everything, and given multi-year terms, typical in master labor agreements, unanticipated matters often arise. Some contracts may also contain clauses that create future bargaining rights and obligations. But even when contracts are silent on future bargaining, when management wants to propose a change in conditions of employment, the statute and case law set forth notice and bargaining requirements. The Office of the General Counsel has 2 key questions when reviewing unfair labor practice charges and change cases. First, is there a change? And second, does the impact of the change support the finding of a duty to bargain? Before examining what represents a change, realize the answers to these questions matter because generally, prior to making a change in unit employees' conditions of employment, an agency must provide the union with notice and an opportunity to bargain over negotiable proposals. So, what is a change? The authorities held that determining whether a change in conditions of employment occurred involves a case-by-case analysis into the circumstances of the agency's conduct and unit employees' conditions of employment. One way to establish a change is to demonstrate a past practice of a condition of employment and then a later proposed modification to that practice. In order to establish a condition of employment by past practice, it must be shown that the practice was consistently exercised over a significant period of time and either followed by both parties or followed by one party and not challenged by the other. Specifically, the authority noted, essential factors in finding that a past practice exists are that the practice must be known to management, responsible management must knowingly acquiesce in the practice, and the practice must continue for a significant period of time. This means one supervisor alone may be insufficient to establish a past practice, and failing to stop a practice is often different than knowingly acquiescing to it. Change determinations are not always straightforward. For example, varying shift start and stop times may appear to represent a change, but if varying shifts is the actual past practice, or if a variety of shifts existed for years and were occasionally rotated, then this example does not represent a change. So ask and answer the question, what exactly was the change? How was it before? How was the change announced? And what is the current practice? Being able to note if an alleged change requires new training, equipment, or skills often helps establish that a change was actually implemented. Now that we explored what a change is, we must next determine if the impact of the change is enough to support bargaining. Let's look at two different authority thresholds to understand this concept. First, starting in 1986, the authority announced and used a de minimis impact standard. The de minimis standard looks to the nature and extent of either the effect or the reasonably foreseeable effect evident at the time the change was proposed and implemented. When unfair labor practice charges assert an agency implemented a change without bargaining, the burden is on the union to establish both that a change was implemented and that the impact was enough to create a duty to bargain. Unions need testimonial evidence establishing impact if they want their charges to succeed. In terms of understanding what is reasonably foreseeable, unions must remember that some theoretical impacts are too speculative to support finding a duty to bargain. There is significant case law regarding the de minimis standard available on our website, which groups cases by topic and allows parties to quickly access specific cases. Second, in 2020, the authority revisited the de minimis threshold and replaced it with a substantial impact standard in the case Department of Education and Department of Agriculture. In 2022, however, the U.S. Court of Appeals vacated this substantial impact policy statement. While impact will be clarified by the authority going forward, it is undisputed some changes will not support the finding of a bargaining obligation based on insufficient impact. Examining the actual or reasonably foreseeable impact is often necessary and may be conducted by the FLRA. What remains clear is that de minimis impacts do not ever support the finding of a duty to bargain. Both parties need to ensure that their assertions regarding impact are credible. Neither unions nor agencies are the final deciders on this point. Both may be required to support their assertions with evidence in judicial proceedings. Having now looked at aspects of term, midterm, and change bargaining, the three times when a duty to bargain may arise, what obligations exist for the agency and the union? An agency must provide reasonable notice and the opportunity to request to bargain, respond to union requests to bargain in good faith to the extent required by the statute over negotiable proposals, generally maintain the status quo until the bargaining process is completed, and cooperate with the Federal Services Impasse Panel if requested by the union prior to implementation. And the union must timely request to bargain, submit negotiable proposals, bargain in good faith, and timely request FISIP assistance if an impasse is reached. This concludes the video describing when a duty to bargain exists. The videos on scope, good and bad faith bargaining, and importantly on defenses to the duty to bargain each include material impacting determinations about bargaining in different situations. For more information, visit us online, and as always, feel free to contact the FLRA for assistance.